Okay, so now let's talk about securitization. All right, so securitization is the process of pooling many thousands of mortgage loans into a trust which issues mortgage-backed securities to investors. The investors that hold those securities have rights to payments that are coming from homeowners. Okay, so a securitization platform generally has 4 parties, okay? And so that is the originator, the sponsor, the depositor, and then the trust fund, which has a trustee. All right? Now, we're going to be going over a particular securitized trust here. It is the Goldman Sachs GSR Mortgage Loan Trust 2006-OA1. All right, so this is a private securitization. You also have government-sponsored securitizations, which are Fannie Mae, Freddie Mac sponsored securitizations mainly. And but this is a private one, so this is Goldman Sachs, and similar ones will be like Citibank and Lehman Brothers and Bear Stearns, and they will all have similar documentation. All right. Now, the laws which pertain to these trusts are the trust indentures, okay, the pooling and servicing agreement and other related trust indentures, the laws of the state of New York, which is where these trusts are formed, the IRS code, Title 26, Section 860, and the Uniform Commercial Code. So these particular types of securitized trusts are called REMIC trusts, Real Estate Mortgage Investment Conduits. Okay, so I'm going to look at their prospectus now, which is sort of like a synopsis of the operation for investors to look at. And again, like I just said, these are the 4 parties. You have the originator, you have the sponsor, you have the depositor, and then you have the trustee of the trust. Okay? So when a mortgage loan gets securitized, it needs to be transferred through all of those parties. All right? And because mortgage notes are negotiable instruments, they need to be passed by possession. So they physically have to be transferred, and then they have to be endorsed. Now, you could just endorse it. You could endorse a mortgage note in blank and pass it on, but there are trust indentures, pooling and servicing agreements, which in many cases state that there needs to be more than one endorsement, and that is to satisfy New York trust law. So let's take a look. Let's take a look at some relevant sections of the pooling and servicing agreement for this trust, and these are very typical. So I'm going to read to you from section 201, where it talks about the transfer of the mortgage loans into the trust, so you can see what's required for a proper securitization. Article 2, conveyance of depositor's interest in trust fund, representations and warranties. Section 201, conveyance of mortgage loans. The depositor, concurrently with the execution and delivery hereof, hereby sells, transfers, assigns, sets over, and otherwise conveys to the trustee, for the benefit of the certificate holders, without recourse, all the right, title, and interest of the depositor in and to the trust fund. In connection with the transfer and assignment of each mortgage loan, the depositor has delivered or caused to be delivered to the custodian on behalf of the trustee for the benefit of the certificate holders the following documents or instruments with respect to each applicable mortgage loan so assigned. The original mortgage note, endorsed without recourse in blank by the last endorsee, including all intervening endorsements showing a complete chain of endorsement from the originator to the last endorsee. And then they go on to list the other documentation that needs to go into to a custodian, actually, to the trustee's custodian for the benefit of the trust fund. All right, so what they're saying there is in order for this securitization to happen, they want the mortgage note to be transferred with intervening endorsements. So we saw that the parties to the securitization are Countrywide Home Loans as originator, Goldman Sachs Mortgage Company as sponsor, GS Mortgage Securities Corp as depositor, and then Deutsche Bank National Trust Company as the trustee. All right? So what you should see for a proper securitization when you look at the promissory note is you should see on the front of the promissory note, you'll see that the lender is named as Countrywide Home Loans. And then on the back of the promissory note, this is a blown up copy of it here, you should see an endorsement from Countrywide Home Loans. Okay, good so far. But then you should also see an endorsement from Goldman Sachs Mortgage Company, the sponsor, and you should see an endorsement from the depositor, GS Mortgage Securities Corp. Now in this case you don't see you don't see those endorsements. Okay? So in this case, and this is very common, extremely common, this note does not comport with the requirements in the trust indentures. Okay? And so New York trust law says that an indenture trustee has to follow the trust indentures to the letter. Otherwise, if there's any ambiguity there, then they don't take title to the property which is being transferred. So that's why the trust indenture says that it's going to be very clear and unambiguous as to who had the notes and who therefore has the right to them. Okay, so this also has to be done by a certain date. All right, and so that is also referred to in the pooling and servicing agreement, and that's the closing date and the cutoff date. And those are two related dates with different functions, but they're close. In this case, the closing date is August 24th, 2006, and the cutoff date is August 1st, 2006. So for this securitization to be proper, right, to be lawful, and for the trustee, Goldman Sachs, or excuse me, Deutsche Bank National Trust Company, to have title, okay, then the promissory note needed to be transferred with all three of those endorsements before the date in August of 2006. Okay, so when we go into some of the other videos where we look at some of the foreclosure documentation, we're going to look at some of that and see if there's any breaks there. We're going to see if there's any documentation which does not comport with the pooling and servicing agreement. Okay, so we did just now see that the note was not endorsed properly. All right, so you're going to have some cases now, some court cases where attorneys for the homeowners are going to be arguing that if the trust indenture is breached, then the trustee did not take title and therefore doesn't have standing to foreclose. And I think that's correct. All right, but that's securitization. And in regards to the MERS system, in the next video we're going to talk about MERS, and we're going to talk about how MERS interfaces with this and the problems that we have with the MERS system. Okay, so see you on the next one.